Olayemi Diekolola Daniels, popularly known as Dieko Spectre, and this is another episode of Dieko Talks Law. And on today's episode, we are going to be talking about articles of association. Definitely it's company law, but then we're going to be talking about articles of association. But before we talk about articles of association, if you are new on my channel or this is not your first time, however you have not subscribed, please, I beg you in the name of Jesus Christ, Allah, and any other thing that you believe in, make sure you subscribe to my channel, like my videos, and support your boy. I beg, do this. Okay, now let us move on. Now, if this is your first time of watching this video and you really want to learn about articles of association, note that there is another video where I discuss about alteration of memorandum. Now, it is very, very pertinent that you watch that video and understand the alteration of memorandum before you can understand articles of association and their alteration. I spoke about how the meaning of both articles of association and memorandum of association in the other video. So make sure you watch the other video. I'm going to put a link in the description below. Make sure that before you watch this video that you look through the link and then you click on it and you watch the video. It is very important to watch that video because a lot of it will be said in that video that will not be said here. So yeah, let us talk about what we're going to have today. Today is going to be slightly boring and slightly interesting. Why? Interesting because it's law, boring because it's alteration of articles. Oh Jesus. But let us go. Let us go straight up to the meaning. So before I go into what we are going to talk about today, let us outline what exactly we are going to be doing today. We are going to start with the meaning of articles. We are going to go into the reason for the alteration of articles. Then we are going to talk about the guidelines for the alteration of articles. We have both the statutory guideline looking at CAMA, which is the Companies and Allied Matters Act as the principal legislation, as well as the judicial guidelines, which are guidelines made by the courts. And I'm going to be talking about the bona fide benefit of the company test, evolved by the court under the statutory guideline. Do note that this video will be divided into three parts. The first part, which is this one, where I'll be talking about the statutory guideline and the bona fide for benefit of the company test, where I'll be talking about the company as an independent entity. And then the second video, which is going to be also the judicial guidelines, where I'll be talking about the bona fide for the bona fide for the benefit of the company test, looking at the subjective test as evolved by the court, and the last video, which is going to be the video discussing the Gamboto's case and also the Sitco's case. Note that this judicial guidelines that I'll be talking about today has 4 cases. The second video, which is the part B, where we're talking about the bona fide for the benefit of the company subjective test, there will be 4 cases, and then the last video would be, that's the part C, would have 2 cases. So let us go straight into the meaning of the meaning of articles. Now, when we're talking about articles, I've already explained in my video earlier what exactly we mean by articles. I mean, when you're talking about articles, you are saying that when you're talking about the internalities of a company, internal affairs of a company, is the articles that govern everything that has to do with the internal affairs of a company, while a memorandum governs everything that has to do with the external affairs of a company. So when the company has dealings with third parties and all that, you have it written in the memorandum. When the company is talking about how their shares are to be distributed or how company directors are to be elected, that is to be spoken about in the internal affairs. And if you want to know more about internal and external affairs of the company, please check my video on the alteration of memorandum. Now we're going to the reason for the alteration of articles. So the question is, why do companies need to alter their articles? Companies need to alter their articles because the world evolves. We as human beings ourselves, we evolve, and also companies also have to evolve. What is obtainable in 1960 cannot be obtainable in the year 2020, and therefore what is obtainable when a company started growing up cannot be obtainable when the company merges. Now, for example, when we talk about the 1968 Act, there are so many things that would have been written or written in the article of a company that was established under the 1968 Act that would not be obtainable under the 1990 Act of Karma. And that's what I'm talking about. So, for example, where a company mandates that its share capital is to be paid in cash, as that 1968 Act, they wouldn't have envisaged anything that had to do with transfer of money, bank transfer, using app and online banking, because that was not there in 1968 Act. But in 2020, when you want to buy shares in a company, you don't necessarily have to go to the company and have to pay cash to hand and all that, and all those things that has to do with buying of shares. So another example would be when Access Bank and Diamond Bank merged. Definitely the articles of both associations would have to change, because the way they governed Access Bank would have been different from the way they governed Diamond Bank. And now that we have a new entity entirely, which is still named Access Diamond or something like that, their articles of association will change. So you can have things like mergers and acquisition, you can have things like new investors, you can have things like initiatives changing, technology changing. So the articles of association has to be at par with what the world is saying, if not to just be lagging behind. And so we need to have from time to time alteration of. We're going to the next part. Now the next part talks about the guidelines for alteration. So when we are talking about alteration of articles, we have to look at two aspects: the judicial guideline and the statutory guideline. But we're going to start with the statutory guideline first. Now, when the starting point in the statutory guideline is section 33 of Karma and section 35(2) of Karma. So let's read section 33 of Karma.
Section 33 of the Companies and Allied Matters Act provides that there shall be registered with the Memorandum of Association articles of association signed by the subscribers to the Memorandum of Association and prescribing regulations for the company.
So let us read section 35(2) of Karma.
Section 35 subsection 2 of the Companies and Allied Matters Act provides that there shall be delivered to the Commission A. The Memorandum of Associations and Article of Association complying with the provisions of this part of the Act.
Now that we have read both section 33 and then section 35(2) of Karma, we are going to say that according to the Companies and Allied Matters Act, it is mandatory that a company has its article of association as well as its memorandum of association. So that's like the starting point. Those are the provisions that mandate a company. There must be an article of association, there must be a memorandum of association. But in this video, we are talking basically about articles of association. Now that we have looked at section 35 sub 2 and section 33, now we have to look at section 34. If we look at the latter part of section 34, it anticipates that a company is supposed to have its articles altered or added, things added to the articles or altered. If you look at the latter part, it admits alteration, omissions, and additions of anything into the article of association. I'm talking about section 34 of Karma. Let us go through it now.
Section 34 of the Company and Allied Matters Act provides that the form and content of the article of association of a public company having a share capital, a private company having a share capital, a company limited by guarantee, and an unlimited company shall be as in parts I, II, and IV respectively of Table A in the first schedule to this Act, with such additions, omissions, or alterations as may be required in the circumstances.
So now that we have gone through section 34 of Karma, let us look at section 48 sub 1 of Karma. Section 48 sub 1 of Karma is the most important part of the statutory guidelines talking about the alteration of articles. So when we look at section 48 sub 1 of CAMA, it will say subject to the provision of the act as well as the condition written in the memorandum and other provisions. A company's article can be altered by special resolution. Now, three things: subject to the provisions of the act, that is number one. Number two, subject to the conditions. And number three, subject to other provisions. Subject to the act, subject to the conditions of the memorandum, and subject to other provisions in the memorandum. Now, in my previous video, I've already explained in total what conditions and other provisions according to this act means. Now, when we are talking about, I'm going to just glance through all of it. Now, when we are talking about subject to the provisions of the act, authority was given again in section 542 subsection 1A of the CAMA. Section 542 subsection 1A of CAMA, which says that at every point the act is always going to be superior to the article of association as well as the memorandum of association. Now, this section 48.1 says that any alteration that is to be made to the article must, number one, be subject to the act. Now, section 542 now reinforces that by saying that the act at every point would have to be superior to both the article and the memorandum of association, which is number one. Now, number two, conditions. Conditions has already been defined by section 44 sub 2 of CAMA. Section 44 sub 2 of CAMA. Now, if you look at section 44 sub 1 of CAMA, it will tell you that conditions in the memorandum cannot be altered except in the manner as specified by the act. Now, what was condition was defined in section 44 sub 2 to be those things in section 27 of the act, as well as other provision to be specified by the act. So other provisions contained in the act, you can find that in section 47 sub 1, which are those provisions which would have otherwise been in the article of association. Those provisions otherwise being in article of association. Now, this clearly defines to us that although section 48 says that a company can alter its articles at any point by special resolution, however, the alteration of the article is subject to the act. Now, subject to the act, subject to the conditions written in section 44.2, and the conditions written in section 44.2, number one is section 27 of CAMA. The section 27 of CAMA would be the first thing that will be in the memorandum of association as condition, and then the second thing will now be the other provisions which is specified by the act. And the other provisions here, you will now find section 47 sub 1 saying those things which have otherwise been in the CAMA. So before there can be an alteration, the alteration must be subject to these three things. Once it is contradicting any of these three things, it means that the article of association cannot be altered. So for the article of association to be altered, it has to be in accordance with the act, it has to be in accordance with the conditions stated in section 44.2, which include section 27 and other provisions in section 44.2, which is section 47.1, which are those things which would otherwise have been in the articles of association. Now that we have looked at section 48.1, we now have to take a look at section 49. What does section 49 say? So let us go through it. Section 49 says that save to the extent to which a member of a company agrees in writing at any point to be bound thereby, and anything to the contrary in the memorandum or article notwithstanding, a member shall not be bound by any alteration made in the memorandum or articles of the company requiring him to, number 1, take or subscribe to more shares. Section 49, number 1, take or subscribe to more shares. Section 49 says, notwithstanding what has been written in the article of association as well as in the memorandum of association, a company cannot alter its article by special resolution to enable a member take or subscribe to more shares than he subscribed to when he became a member. Number 2, increase liability to contribute to capital share. And then number 3, pay money by any other means to the company. Now, there are 2 things that we have to look at there. Now, this alteration are statutory, which means that you cannot alter these 3 things in a company's article. Do note that because the section 542 already says that the act is more superior to section 542 already says the act is more superior to the articles and the memo. Notwithstanding what has been written in the memo, the company cannot alter its articles to enable any of these 3 things. However, there is a loophole to it. The company can only alter its articles to enable the company do any of these 3 things, or a member do any of these 3 things, only when the member has agreed to it in the beginning. And the member must not just agree verbally or anyhow, but it must be put in writing. So if the member has agreed to the contrary in the beginning and then it was put in writing, then a company can therefore alter the articles and then enforce it against and only against such members. It is only against such members that you can enforce it. If or everybody agreed to it, then therefore you can enforce it against everybody. But if only 1, 2, 3, 4 or countable number of people agreed to it, those are the only people that you can enforce it against. So let us go through what we have discussed throughout today. Now, we spoke about section 33 and section 35 to being the standpoint of alteration and memo, like the beginning, where before you can talk about alteration and memo, it is mandatory that the company must have it. Now, when we have seen that yes, a company must have it, and we know what an article of association is, how do we alter it? First of all, we said section 34 already anticipates alteration by stating in the latter part of the section that you can add or alter things in your article. And then now that we've spoken about section 34, we move to section 48. Now section 48 says yes, you can alter by special resolution your articles of association. However, such alteration is, number 1, subject to the act, and which is the same thing as what section 542 sub 1a of the act says. And then number 2, it is subject to the condition. Now, condition was defined in section 44.2 to include section 27, and section 27 talks about the conditions that are supposed to be in the memorandum of association. 44.2 also includes other provision. Other provision will be defined under section 47.1 to include those things that should have otherwise been in the article of association. So now that we have looked at those parts, we now looked at section 49. Section 49 talks about the things that the company is not supposed to alter in its articles. However, the company can alter those things if the parties, that is the shareholders, have agreed to the contrary in the beginning. So from this point, we move to the judicial guidelines of alteration of article. Okay. Now we are going to be looking at the judicial guidelines of, alteration of articles. So while looking at the judicial guidelines, we have to note the first question that we have to ask: what is the business of the court when a company alters an article? The court is concerned with, objection my lord, objection overruled. It has nothing to do with why a company should alter articles, whereas it's already specifically stated in section 48 of the CAMA that by special resolution a company can alter its article. The only time the court should come into this thing is when should come into the picture is when the company do not alter its article according to the provisions. But in this case, you are going to see that there are some times where the court will come to inquire into the substance of the alteration. So the company altered its article from A to say B, and then the court will say, oh, the company cannot say B, the company must always say A, or the company should say A regardless of the fact. Do you understand? So why are courts involved in the substance of the alteration and not in the procedure to discuss the cases? I want us to have an example at the back of our minds, especially the reason why the courts are interfering into alteration of articles. The first, the example is basically, now imagine that there is a company, and then the company definitely would have majority shareholders and minority shareholders, and then the majority shareholders decide to wake up one morning and then alter the articles to expropriate all the shares belonging to the minority shareholders. Expropriate in this case meaning buying all the shares, because they have failed to reach an agreement as to owning the shares. They decided to alter the articles to buy the shares. In this case, it is going to be unfairly prejudiced against the minority of the company, where the majority of the company can at any point in time buy their shares, and that is where the court comes in. So our first case today is going to be the case of Allen. The case of Allen versus Gold Reef West Africa Limited. Allen versus Gold Reef West Africa Limited. Now, before I move into the fact of the case, there are 4 things that we are supposed to note when we are talking about cases in relation to alteration of articles. The first thing we are supposed to look at is what was stated in the company's article. First thing, what was stated in the company's article. The second thing, what did the company alter their article to be? What did the company alter their article to be? The third thing, what did the court hold? What did the court hold? And then the last thing, what is the reason for the court's decision? First thing is what was written in the article of the company. Second thing, what did the company change the article to be? What did they alter their article to be? The third thing, what did the court hold when the case got to court, and what is the reason for the court's decision?
The first case would be the case of Allen versus Gold Reef of West Africa Limited. The articles of the defendant company provided that it should have a lien for all debts and liabilities of any member of the company upon all shares not being fully paid. Gold Reef's article gave it a first and paramount lien. A lien is the right to retain possession on all partly paid shares held by any member for any debts owed to the company. Mr. Zukani held some partly paid shares. He also owned some fully paid up shares issued by the company. Mr. Zukani died insolvent. Insolvent meaning that he died indebted to the company in arrears on call for unpaid shares. The company exercised right under Section 50 of the Companies Act 1862 to alter articles by special resolution, thus omitting the words not being fully paid, and therefore creating a lien over all Mr. Zukani's shares.
So now, in the case of Allen versus Gold Reef West Africa Limited, in the articles of the company had first and paramount first and paramount lien. The company had first and paramount lien over the unpaid shares of any shareholder who was indebted to the company. Now, what did the company do? But before we go into what the company did and what the company altered the articles to be, let us know that there was a man in the company known as Mr. Zukani. Now, according to the fact which has been read earlier, there was a man known as Mr. Zukani. Now, Mr. Zukani was indebted to the company, and then Mr. Zukani had both fully paid shares and then unpaid shares. Mr. Zukani was indebted to the company. Then Mr. Zukani had both fully paid shares and then had unpaid shares. Now, when Mr. Zukani died, he died insolvent, meaning that he died still owing the company debts. And then he had fully paid shares and unpaid shares at the time he died. Now, when you are talking about a lien, in this case where we said that the company had first and paramount lien over unpaid shares, a lien is a possessory right over a property, not the ownership of the property, but just a possessory right. So in this case, when we are talking about, let me give an example. Let's say you have a car and then you took your car to the mechanic's workshop, and then the mechanic had finished work. However, you have not paid the mechanic his fee for whatever he did on your car. Now, as at that point, the mechanic has a lien over that property, a lien to possess the property until you have paid his full money, a lien to possess the property until you have paid his full money. And that is how lien work. Lien is not ownership but a possession. Now, in this case, the company has the right to possess any unpaid shares when a particular person is indebted to the company. Now, when Mr. Zukani died, and like I said earlier, he died insolvent, and then he had both fully paid shares and unpaid shares. What did the company do? The company altered the article to have a lien over all shares, both fully paid and unpaid, by omitting the words having first and paramount lien on unpaid shares. Do you understand? In the company's article, he omitted first and paramount lien over unpaid shares, which means that he had full lien over every share owned by a company, owned by a shareholder, whether fully paid or unpaid, especially when that shareholder is indebted to come through what was written in the article originally, which is the fact that the company would have first and paramount lien over unpaid shares. And then we have gone through what they changed it to, which means that the company will have lien over all the shares, whether or not paid or fully paid or unpaid. And then we know that Mr. Zukani had both fully paid and unpaid shares, and he was also indebted to the company before he died. Now, we now have to look at what the courts have to say, and then we are starting from the first issue. And then the first issue is whether or not the company actually has the right to change their articles to have a first and paramount lien over fully paid shares. Now, in answering that question, the court looked at this issue and said that there are two-pronged tests to it, which is number one, was the alteration done in accordance with the principle of law and equity? When we are talking about the accordance with the principle of law and equity, we have to look at section 48 and ask the question, what does section 48 of CAMA say? Now, when we look at section 48 of CAMA, it will tell you that yes, the company can alter its articles. However, the company cannot alter its articles except in accordance with the act, with the conditions, and with other provisions, and also in accordance with section 49. Without all these things being followed by a company, then the company would not be said to have, followed a principle of law and equity. Now, note that this case is a 19 or 18 something case, but I'm just trying to relate the principles of common law with that of what we have in CAMA. So when we are talking about the principle of law and equity, according to Allen versus Gold REEF, the court was just simply saying that you follow the due process of alteration. Now, when we get to the second part of it, and the question is, what is the second part of it? The second issue. The court is saying that for an alteration to be valid, then it must have been done in accordance with the benefit, the bona fide benefit of the company. So the question is, what becomes the bona fide benefit of the company? I would explain in part 2 of this video, and the part 2 of this video will be bona fide benefit of the company's subjective test. This one is the bona fide benefit of the company objective test, where we look at the company as an independent entity, as distinct and different from the shareholders, the members, the directors, and the rest. So we are asking ourselves a question. The alteration that was made in this case, where the company will have first and paramount shares over first and paramount lien over every share, was it for the benefit of the company? The test here is an objective one, where we have to look at the company as an independent entity. And let's face facts, when somebody is actually owing a company, if you pay the proceeds of the shares back to the person, especially when the person is dead, it is obvious, or we can imply that the person might not be able, or would not want to, that the administrator of the estate would not want to pay the money back to the company. And then it's going to be for the benefit of the company, that for it to still have its money back, then it will hold a lien subject to debt being paid back to the company. So in the interpretation of this alteration to be valid or not, and using the bona fide for the benefit of the company test, the court had to look at it as an independent entity, had to look at the company as an independent entity using the objective test. That when we are looking at the company, we are not looking at it with the shareholders, we are looking at it as against the shareholders, as distinct from the shareholders in this particular circumstance. And according to the court, he held that the alteration were valid. Now, the second issue that was brought before the court was whether or not an alteration that was made could act retrospectively, whether or not it could act retrospectively to an earlier agreement, because that which the shareholders subscribed to was the fact that company would have first and paramount lien only over unpaid shares in the case of debt. Now, can there be an alteration, and then the alteration will operate retrospectively to cover something that happened in the past? Was the question that was placed before. So Lindley MR answered this by saying that every article of association, when being subscribed to, forms a statutory contract. According to section 50 of the Companies Act 1862, which is pari material with section 49(2), as well as section 33, section 35, and every other section 35(2) and every other provision you see in the CAMA relating to articles, especially section 34, the later part of it. It will tell you that when it is a statutory contract, which is what Lindley MR said, that the articles form a statutory contract. When it is a statutory contract, it means that at any point there could be alteration, and when there are alteration, it becomes binding on the shareholders, it becomes binding on the subscribers of such articles. So now, in this case, the shareholders have a statutory contract with the company that at any point the articles could be amended, which must be subject to the principle of law and equity, and also must be for the bona fide benefit of the company. Now, the only time an alteration would not be valid or act retrospectively is when there is a special contract to the contrary. So when there is a special contract saying that no, a particular alteration would not be valid, or an alteration henceforth will not be valid except this and this and this, and that contract is going to be between specific shareholders and the company, then that is going to be upheld. The contract is going to be upheld by the court to say that the alteration is invalid in relation to those shareholders. So now I've gone through Allen versus Gold West Africa, where I spoke about the 4 things that we are supposed to look at, and I've discussed there about the 2 issues we are as well supposed to look at. So now let us look at the second case.